2020. We have a full docket today, and we've made some minor modifications. Obviously, we're starting a little bit earlier than normal, and we have changed our procedure a little bit to expedite our hearing today. But first, let me say that I'm humbled and honored to be in this position and to be continuing working with the very good folks on the board and in the division and with the operators. And however brief my time may be here, I'll try not to embarrass the board or the other members. With that said, I'd like to turn the time over to the board counsel to say a few words and to explain how this meeting will proceed. Mr. Begley, would you like to?
Yes, I believe it goes to, the time is now to Haley Sosa, Division Counsel.
Thank you.
Thank you, Vice Chair Hansen. I just wanted to quickly reiterate that, as you all are aware, but for the benefit of the public who may be watching, that Governor Herbert issued an executive order suspending strict compliance with certain provisions of the Utah Open and Public Meetings Act. The purpose was to limit public gatherings to help to prevent, hinder, or delay the spread of COVID-19. So in an effort to comply with that executive order, as well as other orders that have been issued by the City and County of Salt Lake, the division is making efforts to truncate and streamline all proceedings in front of the board. In this effort, the division will be departing from the traditional format of the board, and we will not be holding a briefing session. However, the division would like to take a few minutes before getting into the docketed items to express thanks to outgoing Chair Ruland Gill. And following that, we will turn directly to the docketed items. So I will turn the time over to Director Baza to give that presentation.
Thank you very much, Haley, and thank you, Acting Chair Hansen, and welcome to board members, all those who are participating in the hearings today, and to those who may be observing via our YouTube link. Before we begin the formal portion of the board's hearings, we want to take time for a special recognition to someone who has been a fixture of our board gatherings for quite some time. At the close of last month's board hearing, Chairman Ruland Gill announced that it was his final board meeting. I think Ruland timed his announcement such that it came as a surprise to a great many people viewing the proceedings that day, but also we in the division had little time to react to the announcement. So I'm attempting to correct the division's lack of reaction to last month's announcement by offering some nominal amount of recognition to the service that was provided by Mr. Ruland Gill over the years of being part of our board and division family. My own personal acquaintance with Ruland dates back to when I was a young engineer with the division during the 1980s, and he was a corporate attorney for Questar Corporation. Even back then, and yes, about 30 plus years ago, he was serving as a guide and sharing his expertise with me on matters of oil and gas conservation, spacing, pooling, unitization, and rulemaking. I'm grateful for the knowledge that he passed on and for the working relationship that we established those many years ago. But the recognition that we give to Ruland today is for dedicated service on the Board of Oil, Gas, and Mining that commenced in March 2007, when he was appointed by then Governor John Huntsman. During that time, the board spent countless hours in hearing and made numerous decisions related to effective and efficient development and regulation of Utah's extractive industries, and Ruland was no small part of that. Some notable board achievements that stand out in my mind are decisions regarding the commencement of the Alton coal mine in southern Utah, the horizontal drilling pilot projects in the Uinta Basin, and especially the awards that have been given over the years for environmental excellence by the board for those who excel in Utah's mining and petroleum industry. So during this time of uncertainty that we have right now, and due to circumstances of pandemic and economic disruption, we're challenged, but we're only challenged by being able to offer a token gratitude for Ruland's dedicated service. So with the few small minutes that we have today, we recognize the many hours that he spent in attempting to improve and advance oil, gas, and mining activities within the state of Utah. We've provided some small mementos of our appreciation that are sitting with Ruland in the auditorium today. We do have a short video that we would like to show, after which we might hear some comments from Executive Director Steed and Mr. Gill himself. But I think we can go ahead and cue up the video and see what the division is prepared to recognize Ruland. And we're just awaiting our technical team to get that video up and running. So truly, thank you, Ruland Gill, for your service and dedication. I think that Executive Director Steed and perhaps even Ruland would wish to make a comment or two right now.
Absolutely. So thank you, Ruland, for a tremendous number of years of great service. As we look at those pictures that were taken over the time frame that you served on in this capacity, it strikes me that perhaps we should have gotten you a hard hat for for a going away gift. It's a weird time in our country, and it's a weird time here in the division, and change makes that even weirder. You have been a fixture in this building. You've been a fixture on this board, and we truly appreciate the number of years that you've been willing to give. You've served with passion, with dedication, and with knowledge, and you're one of those people that everyone scratches their head and say, "How do we replace a Ruland Gill?" And that's not a straightforward answer. And so I just wanted to say from all of us here at DNR, thank you so much for a job well done. Thank you so much for your willingness to be part of this team, and thank you so much for your service to the state of Utah and its citizens.
Thank you very much. The division and the director were able to give me this great, this as well. Oh, there's more? Oh my goodness. Howard and Miller. I'm not sure how to get into this.
It's the chest.
Oh, it's a clock, a beautiful clock. Thank you so much. I appreciate that. I would like to thank a few people. Executive Director, your solid hand at the helm has been great. And John Baza, I can't say enough about your steady, calm nature and your staff, the things that we've been able to look at. As I recall, I was mentioning to the board and to you that we had about 15 straight months of matters of first impression. And then to you board members, thank you for believing that we could do something out of the ordinary, that we could go to the legislature and pass some bills and have a pilot project that would work. It took a lot of faith. Yeah, there were some bumps in the road, but those were good bumps because we needed to find out and learn and discover what was needed for the industry. And then to the division staff, I just can't thank you enough for all the things that you did for the board to make our trips, our hearings so successful and efficient. For those, for Paul and his team that did put together the remote testimony cameras that started out with his private ones, and now we're onto these high-tech ones. And of course, to Julianne Carter and her abilities to keep the board organized, but mostly to keep me organized. And then to the board members that sat next to me and said, you may want to think about getting back on the agenda, or you missed something or something else. It's been a great run. I feel like I'm the luckiest person in the whole state of Utah today, and I want to thank each and every one of you, and particularly you board members, for your service and your trust and for our accomplishments. I know you have a big schedule, and I'll leave it at that, but thank you very much. I couldn't be more proud of all of you and for what we've been able to do. Thank you very much.
So thank you.
Thank you. Thank you very much.
Mr. Hanson, we'll turn the time back over to you for the remainder of the board tenure.
Thank you, Mr. Baza and Mr. Chair, Ruland. Thank you, and thank you for your years of service and what you've taught me personally. Stay in touch, please. We'll now move on to the agenda items on our docketed agenda items in our hearing. The first docket item, need to put on my glasses so I can read this. Docket number 2019-014, cause number C/007/0045. Request by the Utah Division of Oil, Gas, and Mining to forfeit the reclamation surety in order to complete reclamation of the Wellington dry coal cleaning facility. I won't read the rest of this, but it's my understanding that this has been continued, possibly to the July hearing. Is that correct, Ms. Sousa?
Yes, it is. Thank you.
Okay, well, that will be, then we anticipate hearing that on the July 22nd board hearing. The next item on the agenda is docket number 2020-003, cause number 479-01. In the matter of the request for agency action of the Betty T. BOWDEN Trust to set for investigation and a hearing to determine why NADK LLC has not paid proceeds attributable to royalty interests on production from the Alta 5-1-B well located in Section 5 of Township 7 South, Range 21 East, and the Alta 5-2-C well located in Section 7 of Township 7 South, Range 21 East, both in Uinta County, Utah. In this matter, I believe we will hear a report first from the division on the results of the investigation and negotiation. Division, please proceed. I'm not sure who is going to be giving this summation, but please proceed.
It will be me. This is Haley Souza. Thank you. Before I begin, I'd like to state that there are people on the line, both from the BOWDEN Trust and also from NADK. While neither of these are natural persons and therefore cannot or not are allowed, I'm sorry, are not allowed under the rules to address the board without Utah licensed legal counsel, I'd like to express that the division does not object to the board hearing from either of these parties.
Perhaps a motion is in order from the board members that we suspend the rules for requiring natural persons to be represented by legal counsel so that they may provide testimony. If the board agrees, we could have a motion.
So moved.
I did. Just curious that everybody heard that.
Did that work? Am I on?
Can you hear Ms. Davis?
Yes, we heard Ms. Davis.
Yes, and I'll second that. This is Gordon.
Thank you, Mr. Moon. The motion has been put forth. Is there any discussion on the motion? Hearing and seeing none, let's have a vote. All those in favor of the motion, please say aye.
Aye.
And raise your hand. Oh, I'm sorry. I'm being taught that we need to do a roll call vote. Julie, Ann, could you make this happen?
Yes, of course. Mr. Richard Borden, how do you vote, yay or nay?
Yay.
Mr. Michael R. Brown, how do you vote, yay or nay?
Yay.
Mr. Stephen Church, how do you vote?
Yay.
Susan Davis, how do you vote?
Yay.
Chris Hansen, Vice Chairman, how do you vote?
Yay.
And Gordon Moon, how do you vote?
Yes.
Mr. Vice Chairman, I have 6 affirmative votes.
Thank you, Julianne. With the motion passed, I think we will hear testimony from these folks. Please continue, Ms. Sousa.
Thank you. So Beverly Weiser with the division conducted the investigation and negotiation, and she was actually in contact with the parties long before this action was filed with the board. The findings detailed in the division's memorandum include facts obtained prior to the official filing of the board. Ms. Weiser had 32 discrete interactions with either the Bowden Trust or with NADK dating back to March 2019. During Ms. Weiser's investigation, she determined that NADK was the operator of 2 wells, the Alta 5-1-B well, which I may call subject well 1, and the Alta 5-2-C well, which I may call subject well 2, or I may collectively refer to these as the subject wells. So the division approved of the change of operator for these wells in January of 2018. These wells produced between January 2018 and May 2019. NADK purchased these wells from Summit Operating LLC. And at the time of the purchase, NADK indicated that it was not able to obtain royalty owner records from Summit and therefore could not make the required payments. In July of 2019, the division acquired a list of the royalty interest owners from Summit and provided that list with their addresses to NADK. After NADK received this list from the division understands that NADK did not make the required payments for lack of funds. So at the time that NADK purchased the subject wells, Betty T. Bowden owned a royalty interest of 0.021649% for subject well 1 and a royalty interest of 0.03125% for subject well 2. Betty T. Bowden passed away on January 8th, 2018, and her royalty interest passed to her heirs, the Betty T. Bowden Trust. The trust recorded its certificate of trust with the Uintah County Recorder and notified NADK that it had recorded that trust. So according to the division records that it has on hand, the division estimates that, so the records indicate that subject well 1 during the 17 months that it was producing sold a total of 3,989 barrels of oil. And using the Chevron monthly average oil price, the division estimates that for this subject well, the Bowden Trust would be owed approximately $4,550. During that same time, subject well 2 sold 3,758 barrels of oil. And using the same method, the division estimates this would be approximately $5,510 owed to the trust for royalty payments for subject well 2. NADK notified that the division that it had not placed proceeds for royalties into an escrow account. And NADK has also indicated that it has entered into an agreement with a buyer to purchase the subject wells. And while NADK does not have a written purchase and sale agreement, it is their understanding that if that sale does go through, that the buyer will pay past due royalty payments as well as past due property tax payments. So when the board is conducting an investigation into why proceeds haven't been paid, there are really two things that the board should consider. The first thing is whether the delay of payment was done with reasonable justification. And the second is whether the proceeds have been deposited into an interest-bearing escrow account. So I will turn now to the first the first item that the board should consider, and that is whether delay of payment was done with reasonable justification. So Utah Code Annotated Section 40-6-9 sub 8 lists 4 situations wherein an operator may suspend payment and have reasonable justification. So in the first situation is when the operator fails to make payment based on good faith reliance on a title opinion that was commissioned, and that title opinion questions that the person claiming rights to payments has good and marketable title. So in this situation, the operator must also provide the title opinion to the person claiming entitlement and allow that person to cure. In this situation, the division does not have reason to believe that NADK commissioned a title opinion. The second situation is when the operator receives information which calls into question the person's right to receive payment, information that renders the title unmarketable, or information that exposes the operator to risk of liability to third parties if payment is rendered. So the division does not have reason to believe that NADK received any such information such that payment should be made under this specific situation. So in the third situation under the statute is when the total amount of the proceeds owed at the end of any month is less than $100. So without having complete specifics on how much NADK sold oil from the well for, there appears that there may be some months where the proceeds owed at the end of the month did total less than $100. However, because NADK failed to make payments in the months where the amount owed was in excess of $100, the division does not believe that NADK meets the spirit of this subsection either. So in the final situation is when a person entitled to payment has failed or refused to execute a division of transfer order acknowledging the proper interest to which the person claims to be entitled, setting forth the mailing address to which the payment was directed. So the BOWDEN Trust did not provide a copy of the certificate of trust to NADK, thereby notifying NADK of its proper address until November 19th. But the division nonetheless does not believe that NADK meets this subsection either. Without knowing that the BOWDEN Trust had taken ownership of the royalty and interest, NADK made no effort to remit payment to Betty T. BOWDEN. The division didn't uncover any evidence that NADK was aware that Betty T. BOWDEN had passed and that her portion of royalty payments should be withheld until notification from the heirs. So as such, the division does not believe NADK can reasonably rely on this option either to demonstrate reasonable justification for withholding payment. So based on the investigation and negotiation, the division does not believe NADK meets any of the statutory requirements providing reasonable justification for withholding payment. So then there's the second thing that the board should consider in any hearing to determine why proceeds haven't been paid is whether the proceeds have been deposited into an escrow account. And this matters because it affects the type of award that the board can grant. So in this situation, NADK has stated that they have not placed the proceeds into an escrow account. So I will focus my attention on situations where that is applicable. So the statute states that in instances where the proceeds have not been deposited, the board may order first that a complete accounting be made by the operator, and second that the proceeds be subject to an interest rate of 1.5% as a stand-in for that interest rate that the proceeds would have earned had they been deposited into an escrow account. So finally, in instances where the funds have not been deposited into an escrow account, After a hearing, if the board determines that delay of payment is without reasonable justification, as the division argues in the current case, the board may assess a penalty of up to 25% of the total proceeds and the interest. The final piece of the statutory puzzle is a mandatory requirement for the board, and that is that if the board determines that the petitioner was entitled to payment but did not receive payment, the board shall set a date for final distribution of the total sum, which is no later than 90 days from the hearing. And if time for payment passes without remittance, then the board shall order the proceeds, interest, and any penalty that the board may choose to impose be subject to a 1.5% interest rate per month until full payment is made in full. The division's recommendation is that the board order that a complete accounting be made by NADK, that the proceeds be subject to an interest rate of 1.5% per month as a substitute for the escrow account interest rate accruing from the date the payment should have been suspended in accordance with Utah Code 40-6-9 sub 3, and determine whether a penalty of up to 25% of the total proceeds and interest is warranted in this situation. And Vice Chairman, I am done with my presentation.
Thank you, Ms. Sousa. At this time, do the members of the board have questions for the Division Council? Ms. Davis.
Were other royalty owners paid during this period?
The division does not believe that they were.
Any other questions from the members of the board?
Yeah.
Mr. Moon. Please
Yes.
proceed, Mr. Moon.
So get their acronym right, NADK, what have they said other than first, we didn't know who to pay, and secondly, we don't have the money? Is that basically where they're at now? They're just saying we don't have the money to pay?
Yes.
Okay. And you've had like decent correspondence with them, or?
My understanding, Bev Weiser has handled the correspondence with both the BOWDEN Trust and with NADK, but my understanding is that both have been relatively responsive and have provided her with information that she's requested. Sometimes she has had to ask more than once for the information, but ultimately she has been able to have phone conversations and email correspondence with both of the parties.
But NADK has never made any attempt to pay. Is that correct?
That is correct.
Thank you.
Mr. Borden.
Yes, could you tell us, are these wells still producing? Does NADK still have likely cash flow in the future from these wells?
No, these wells haven't produced since July 2019. No, May of 2019 was the last time that these wells produced. I am not sure whether or not the wells continue to be viable, but I believe that with the transfer of ownership, there's a possibility that they are still viable.
Thank you.
I do have one question if the other board members are satisfied. Seeing no other folks raising their hands, Ms. Sousa, what will happen to the monies owed, or what will happen to the process if the sale does not go through? What will the division do?
The division doesn't have the authority to do anything to force NADK to pay the proceeds. That would have to be taken up by the BOWDEN Trust in a district court setting.
Thank you. Okay. When would you like to ask those questions? Okay. I should have Mr. Begley here at my right side, but with the restrictions in place. If there are no other questions or comments at this time, perhaps we could go to the persons representing the trust. If you're participating, please introduce yourself, say your name, spell them for the reporter, and give your address, mailing address, so that we can have that for the record. So if you'd like to, go ahead. Oh, we do.
Okay, sir, I think the mic is good now. My name is
Okay.
Deanne Kazi.
I believe I'm before or after, Mike. Okay, I'm sorry to interrupt. Go ahead. After your introduction, we will have you sworn in.
Okay, thank you. My name is Deanne Kazik. Spelling is DEEANNEKAZECK. Additionally, with me is another trustee, my sister, Lorraine Oliver.
Yes, it's Betty Lorraine Oliver, BETTYLARRAINEOLIVER.
And the address that you received mail?
845 North, 2050 West, Vernal, Utah 84078.
And for Deanne, 847 North, 2050 West, Vernal, Utah 84078.
At this time, if we could have the court reporter go ahead and swear them in.
If you would raise your right hands, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. If you would like to proceed with your testimony, please do so.
This is Deanne. I'll start. I initially contacted Mr. Knowles upon finding that the wells had changed ownership by doing a search, because prior to my mother's death, I found that she hadn't been receiving any royalties since I think about September of 2017, and she passed away January of 2018, as was earlier stated. So it fell on us as the trustees to see that her affairs were taken care of. So I contacted Mr. Knowles on July 11th of 2018, advising him that, or informing him that I'd seen the change of ownership. She hadn't received any royalties since the transfer, or maybe even possibly before the transfer. He indicated that he didn't know the percentages of the wells and things like that. So my only thought of what I could provide him with for that information was copies of the last producer's royalty checks to my mother, and that had an indication of what the percentages was, and I felt like that gave validity that, you know, we were entitled, or she and her estate was entitled to royalties. So I think it was on about August 8th or August 11th, excuse me, of 2018, that I provided him with that information because we had to go through her records to find it. I got an acknowledgement from him on that point, and then there was no further contact, or I could get no further response. So on March 7th of 2019, I contacted the DNR, Division of Oil, Gas, and Mining, for some help of what to do. And that's when I was in contact and reached out to Miss Weiser. I don't know what else to give you beyond that.
I apologize. I was seeking some counsel from our counsel. At this point, I believe we can have a representative of NADK give their testimony. They would have to be sworn in and introduced. If there's anybody present today that would give this testimony.
Yes, I'm here.
If you could introduce yourself, and then we'll have you sworn in.
My name is Dave Knowles. Knowles.
Will you raise your right hand, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
If you could tell us what your relationship is to NADK and also your address.
Yeah, so I'm at this point the owner of NADK. My address is 742 East, 750 North, Orem, Utah, 84097.
Thank you. If you would go ahead and proceed with your testimony.
Okay, I don't contest money owed to the BOWDENs or interest. Do anything in my power to help them to get that. Payment wasn't withheld maliciously. I mortgaged my house and put every penny of my retirement and savings into the company. All the money that was made from sales was directly put back into the company, taking nothing for myself. I had one of the big problems was not understanding the royalties going into it. I don't have an oil and gas background. And I kind of learned as I went. And at the time we purchased the wells, I had a business partner. He was to handle all of the paperwork and books and reporting and all of those things. And I did the physical work on the wells. They were extremely dilapidated. And after the purchase, we realized that they were much more dilapidated than we'd previously known. My business partner at the time was telling me that he was taking care of these things, but wasn't. He ended up found out that he embezzled $160,000 from the company, and there's an ongoing investigation on that. But by the time I understood what was going on, I was just trying to put money into hauling off water and getting, being able to keep the wells producing. They kept going down at different times for different reasons. But having said that, I do whatever I can. I don't want Bowden Trust to be out anything. And I apologize to them. And I'll do anything I can. NADK is probably the best bet of people getting paid is a bankruptcy. I don't even know if that would do it, but I found out the hard way that the wells are basically worthless, and spent a lot of money doing that. But so I'll take whatever the board has as a recommendation, and in my power as the manager of NADK, I'll do whatever I can to make sure that they're paid. There's no hope of, for me anyway, of capital coming in right now. My best option is I'm going to turn the wells back over to the original owner. I'm not going to receive any money for it. And they're supposed to pay the taxes as stated and the royalties.
Mr. Knowles, does that conclude your testimony?
Yep.
Thank you. At this time, we'd like to give the division an opportunity to follow up with any questions of either party, if you would like. Ms. Sousa?
I don't have any additional questions. Thank you.
Board members, do you have any questions you would like to ask either of these parties at this time? Mr. Moon.
Yes, so it's going back to the original owner. Do they have the ability so let me clarify, they have committed to pay these back royalties? And second question, do they have the financial ability to do so?
I assume so.
Okay, I'm done.
Thank you. Now, this is a difficult situation. I think at this point, perhaps the board members would like to deliberate on this matter. But how much time do you think we should allow for that deliberation, Mr. Counsel? Oh, I'm sorry. I did not see you, Ms. Kasich. You have a question.
Yes, sir, I do. When Mr. Knowles and Mr. Moon talk about the original owner, is that going back to Summit? I would just like to know who the new producer is going to be. Because there's been, on these two wells, there have been multiple producers over the life of the well since 1960.
So I can answer that for you. I think there was a little confusion earlier. The owner that I bought the wells from, NADK did, his name is Dave Sweat. And he had owned the wells together with Summit. And Summit was still the operator on the wells when we purchased them.
Can I get a clarification? Can you just repeat the name of the owner for me?
David Sweat.
Thank you.
Any other questions you would like to ask?
And is Mr. Sweat a viable option to take over the lease on these?
Well, he operated them before. If he does take them over, it'll be contingent on paying those back taxes and royalties. So that's all I know.
Yeah, go ahead, Ms. Oliver.
Yes, I have a question for Mr. Knowles. Have you been in direct contact with Mr. Sweat regarding these issues?
No, I've been in contact with his attorney.
Thank you. Can you provide that? I'm sorry.
I'm sorry.
Can you provide that attorney's name?
Yeah, I have it, but I don't have it in front of me. I could provide it.
Thank you.
Okay, thank you. I believe that what we will do is go into deliberations on this matter. It's currently 9:30, 9:31. We should take about 20, 25 minutes, be back. Well, let's just make it an easy half hour. We'll be back at 10 o'clock, if that's okay. So we'll go off the record at this point and go into deliberation.
5 seconds. 5, 4, 3, 2, 1.
Thank you. We are going to go back on the record at this time, and we will entertain a motion on this matter, on the Betty T. Bowden Trust matter. I believe Ms. Davis has a motion.
I do. I would like to move that we adopt the division recommendation, which is that a complete accounting be made by NADK. The proceeds will be subject to an interest rate of 1.5% per month, and there will be no penalty. So that's my motion.
Would you like to add to that motion 90 days?
Oh, yes. Yes, there will be given 90 days to make that accounting. NADK will be given 90 days to make a complete accounting and distribution to the Betty Bowden Trust.
Thank you, Ms. Davis. Is there a second?
This is Gordon. I will second that.
Thank you, Mr. Moon. Is there discussion on this motion?
Chairman, I have a question.
Mr. Brown.
Thank you. This is Mike Brown. I have a question for the division. Ms. Souza, I'm quite concerned about the future of this well, or these two wells, and wondering what, if any, bonding the division holds for reclamation purposes.
Sure, the division holds a $120,000 blanket bond for these two wells, plus I believe it's 3 other wells. I think that NADK may have 5 wells. That is a question that if I'm wrong, hopefully Bev Weiser can jump in on, but they do carry a $120,000 blanket bond.
This is Bev Weiser. Can you hear me?
Yes, Bev.
They do
Bev.
carry a, sorry, they do carry a $120,000 bond. And it's for state and fee wells only. It's not for any of the other wells. And I was trying to pull up my program to make sure, because I pulled up, because I have it up, to make sure what wells they have. What ownerships they have in those wells, other wells. And it looks like there are only all the other wells, all of the other wells are federal wells. So that 120,000 is only for those 2 state wells. Does that answer your questions?
Yes, thank you. Mr. Chair, I yield back.
Thank you, Mr. Brown. We've had the motion. It's been seconded. We can proceed to a vote. Ms. Julianne, if you would take a roll call vote on this matter.
Yes, Mr. Chairman. Mr. Richard Borden, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yay.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yay.
Mr. Vice Chairman Chris Hansen, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Yay.
Thank you. Mr. Vice Chairman, I have 6 affirmative votes.
Thank you, Ms. Carter. The vote was unanimous. I would like to ask Ms. Souza to explain how the process will work going forward at this point.
Sure. So the board's order will, if not carried out by Mr. Knowles, the Bowdens could take that order and file it in district court and have it converted to a civil judgment, at which point they would have all the remedies available to them that a civil judgment would entail. So that could include garnishment or other remedies that may be available to them. But the order would need to be filed in district court and be converted to a civil judgment.
Thank you. Ms. Souza, would you be kind enough to memorialize the board's decision on this matter?
Certainly.
Thank you. That concludes this matter. Appreciate those who have provided testimony and wish you good luck. We will move on to the next matter if there's no other issues. The next matter is docket number 2020-005, cause number 379-01. In the matter of the request for agency action of HIGHPOINT Operating Corporation to set for investigation and a hearing to determine why Paradox Upstream LLC has not paid proceeds attributable to its overriding royalty interest. At this point, I think we would like to hear the report from the division. Again, I assume that is Ms. Souza.
This matter has actually been continued until next month. I believe the order on it went out yesterday. My understanding is that the parties have reached an agreement wherein they believe that by next month, a full payment can be made. So HIGHPOINT's counsel filed a motion to continue, and they expect that if the full payment is made that next month, they will be able to file for dismissal.
Thank you, Ms. Souza. This matter is continued until next month. The next item on the docket is docket number 2020-016, cause number 132-03. In the matter of the request for agency action of XCL Resources LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners. I believe at this time I believe this matter was heard by a hearing examiner, and if I'm correct, I believe it was Mr. Rogers who was the hearing examiner.
Correct.
If you would like to proceed.
Thank you, Vice Chairman Hansen, and good morning, good morning to the members of the board. My name is John Rogers with the Division Oil, Gas, and Mining, and I was appointed by the board to act as a hearing examiner for this matter, request for agency action for XCL Resources LLC, docket number 2020-16, cause number 13203. Mr. Hansen has outlined the details of that, so I'll proceed with what we undertook in this matter. The cause came before me as a hearing examiner on June 17th, 2020. This matter was unique, but not so uncommon now that all parties were present virtually on their computers, just like we are today, due to the COVID-19 pandemic and self-isolation requirements. I'm happy to say the process went very smoothly and is improving with each hearing. Haley Sosa, Assistant Attorney General, appeared as counsel for the division. Mr. Mitch Mayo represented XCL Resources, and XCL had two witnesses. My counsel was Gordon Rowe with Attorney General's office. The drilling unit in question is a stand-up unit located at Township 2 South, Range 2 West, Section 26 and 35 of Uinta Special Meridian, Duchesne County, and it has two horizontal wells proposed. The DSU is about 5 miles southwest of Roosevelt, Utah, and the oil and gas on the underlying drilling unit of 2635 are owned almost entirely in fee, with a small portion owned by Sitla. Only one working interest owner has neither agreed to participate nor sign a JOA and tender its proportionate share of costs in the drilling and completion of the subject wells. That owner is Robert L. Bayless, Producer, LLC, which has a 1.02% working interest in the drilling unit. In reference to Bayless, an election offer was mailed to Bayless on March 10th and received by them on March 12th of 2020. As of the hearing, an election was not made or signed by Bayless and received by XCL. A comment letter was received from Bayless to the board on June 10th, 2020, with comments for requests for this board. Issues that I considered when considering this letter were the following. The lack of timeliness of the comment letter. It came 90 days after the first arrival of the nomination. It was not filed by a licensed attorney as required by R641-102-200. There was no representation by Bayless at the hearing. And the JOA by XCL presented was accepted by all other working interest owners. And it is a standard JOA that accepted in the basin for joint operation agreements. After hearing testimony and facts, it was my determination that XCL has sustained its burden of proof and demonstrated good cause for granting its oral motion to strike the request made by Bayless in its June 10th, 2020 commenter. Therefore, I recommended to strike the request of the letter and represent it as a comment from the public. The majority of the mineral interests under the lease to XCL and the other consenting workers owners is approximately 98.98% of the interest with a subject drilling unit and are voluntarily pulled by contract. Tied to some of the underlying oil and gas interests with subject drilling units remains vested in 3 parties now determined to be believed to be deceased. XCL has conducted diligent investigation into the estates of successors. While XCL believes there are some or all such successors are not released, there are no final Utah court orders confirming the successors to the estates. Notice was published in the Uinta Basin Standard, the Vernal Express, the Salt Lake Tribune, and the Desert News. As evidenced by the petitioner's exhibits submitted in evidence and related testimony received at the hearing, I believe XCL attempted in good faith to secure the voluntary participation in the subject wells of interest of the non-participating working interest owner, which efforts ultimately proved unsuccessful. After hearing testimony, it is my judgment that XCL has conducted an investigation into finding unlocatables and successors to lease or participate in the wells. Based on evidence and testimony presented at the hearing, I am recommending the risk penalty for all subject wells to be 300% non-consent penalty. In conclusion, based on the evidence and testimony submitted during the hearing, I, in my role as hearing examiner, find that XCL has proven the need for compulsory pooling of this drilling unit. However, there are some unique legal questions that I'd like to turn over to my counsel, Mr. Rowe, for some clarification.
Thank you, Mr. Rogers. Gordon Rowe, Assistant Attorney General. I represented the hearing examiner in this matter. As part of the division's effort to better conduct board hearings in light of the pandemic, this matter came before the hearing examiner on an expedited schedule. As a result, the parties and the hearing examiner had a very limited time to draft and review the hearing officer's proposed order. All the parties are in agreement as to the substance of the order, and the hearing officer recommends the board grant the relief sought by XCL in their request for agency action. However, there is one paragraph in the order that the hearing officer feels needs a bit more clarification. Specifically, paragraph 6 in the order contains language that the hearing officer feels may need to be slightly redrafted. However, we feel that this will not affect the substance of the order. Therefore, the hearing officer would recommend the board today grant the relief sought by XCL without adopting the version of the proposed order filed yesterday. This would allow the hearing officer and I, counsel for XCL and board counsel, to work on clarifying language for this paragraph 6 after the hearing. Once we've all found language that's acceptable to all the parties, XCL could file an amended, or I guess it would come from the hearing officer, would file an amended proposed order for Chairman Pro Tem Hansen's signature. So that's the recommendation from the hearing officer at this point.
Thank you. Mr. Rogers, is there any other comment you'd like to make at this time?
Well, I would like to know if any of the other attorneys involved, either Ms. Souza, Mr. Begley, or Mr. Mayo, would like to comment on that.
Thank you. I'd like to ask Mr. Mayo if he'd like to take a moment to make a comment.
Yeah, I would, and I hope the board will indulge me for one quick second. I was at the last hearing when Chairman Gill announced his retirement. In my short time practicing before the board, Chairman Gill has been the chairman the entire time, and I would just like to thank him personally for his service, and also assure him that the board is in good hands with the existing board members who will stay on board. So thank you for that indulgence. To the question you asked, I agree with everything Mr. Rogers and Mr. Rowe have said about the order. There has been an issue that was raised yesterday around 3 o'clock with one of the provisions in the order. XCL does not believe it's problematic, but out of deference to the situation and the struggles we are all under trying to get things finalized, I'm comfortable with continuing down that path to address this at a later date with a revision if necessary to the order.
Okay, thank you, Mr. Mayo. I apologize I did not introduce you properly, but you took care of that.
Oh, thank you.
So I guess the matter before us, or what we need to be voting on, is to make a motion, entertain a motion that we accept the findings of the hearing officer with the caveat that the issue in paragraph 6 be addressed by the attorneys in this matter. Board members, is there any discussion you would like to have on this?
Yes.
Ms. Davis.
Mr. Rogers, in looking at the JOA, was there anything unusual in the fill-in portions of the JOA?
Not that I noticed, and it was presented as pretty much the standard JOA that is used out in the Uinta Basin, and all other operators signed on it. And so it's my determination that it would be unfair to alter that for this party at such a late date. And there was some negotiation that went on between XCL and Bayless, but it didn't prove to come to either side to agreement. And did you happen to see the letter from Bayless that they were requesting?
Are you asking me?
Or anyone on the board? Did that letter get, you saw that, the Bayless letter?
Yes, it's in the file.
Okay.
One additional thing, if I may, Chairman Pro Tem, is address Ms. Davis's question a little bit. At the outset of the hearing examiner hearing, I made an oral motion to strike those requests. Mr. Rogers consulted with Mr. Rowe and agreed to take it under advisement, but we stipulated that the division was not prevented in any way from addressing those same concerns raised by Bayless. And from XCL's perspective, the division through Ms. Sosa did a full-throated examination of the issues raised in the Bayless letter, despite Mr. Rogers' eventual granting of the motion to strike those requests. So Bayless requests were stricken by Mr. Rogers' order from the letter, but the concerns raised therein were from our perspective, fully addressed before the hearing examiner entered his recommendations.
Thank you. Other board members, any questions that you'd like to ask the division or Mr. Mayo on this matter before we go to accepting a motion? Seeing none, I would think a motion is in order. If someone would like to make the motion to accept the hearing officer's findings with the caveat of amending paragraph 6 of the order.
Mr. Chairman, this is Mike Brown. I will make that motion that we adopt the hearing examiner's recommendation with the caveats as presented by legal counsel.
Thank you. Is there a second?
I second that.
Thank you, Mr. Church. We've had a motion and a second. Is there any discussion on this motion? In that case, seeing none, Ms. Carter, could we have a roll call vote on this matter?
Mr. Richard K. Borden, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yay.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote?
Yay.
Vice Chairman Chris Hansen, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Yay.
Mr. Vice Chairman, I have 6 affirmative votes, excuse me.
Thank you, Ms. Carter. The vote is unanimous on this matter. And I am told that the attorneys will take care of correcting the issue. And before we move on to the next matter, I'd like to thank XL and their representative, Mitch, for being agreeable to put this matter through the hearing officer system. It's been a big help in helping us to control our schedule, and I know it's a lot of work and effort on your part, and thank you and the division for doing this.
You're welcome. Thank you.
Yes. And I'd like to recognize Mike Begley.
Thank you, Chairman. On that note, Mitch, please report back to your client that I'm hopeful that we as the attorneys can get right to work on paragraph 6. I don't think it will take very long, and I'm anticipating hopefully getting this order issued by the end of the week.
I will do that, and I have the same anticipation. So I look forward to talking to you, Mike. Thanks.
Well, thank you. The next item on our agenda is docket number 2020-009, cause number S02100035, in the matter of the notice of agency action by the Utah Division of Oil, Gas, and Mining, seeking an order, 1, affirming the division's withdrawal of the notice of intent to commence small mining operations for the Highland Mist Mine, 2, forfeiting reclamation bond provided by Cornerstone Industries, Inc. for the Highland Mist Mine, and 3, authorizing the division to use the amount forfeited to reclaim the surface of the Highland Mist Mine. It is my understanding this matter has been continued from the May 27th board hearing, and that we will hear from the division on this matter. Please proceed.
Thank you, Vice Chair Hansen. The parties have come to a mutually acceptable agreement, and the division filed a motion to dismiss on Monday, and I believe that order went out yesterday. So there's nothing, the division doesn't need to present anything on this matter.
Okay, thank you. And there's nothing more that the board needs to do at this point, so we will move on to the next item. The next agenda item is docket number 2020-011, cause number 475-02, in the matter of the request for agency action of Middle Fork Energy Uinta LLC for an order suspending Utah Administrative Code Rule R649-3-2, R649-3-10, and R649-3-11, 1 and 2 as to the KJ2 federal unit. In my notes, I had that this may be assigned to a hearing officer at the division. I believe it might be appropriate to hear from the division at this time to see where we are on that, the progress on that.
Sure, that matter has been assigned to a hearing examiner. The hearing examiner will be Mr. Rogers, and it has been, it will be heard on July 8th at 9 a.m. And the division expects that the hearing examiner's recommendations resulting from that hearing will be presented to the board in the July hearing.
Thank you. Just making some notes. I don't believe we have any other business on this matter, so we will move on to the next item in our agenda is docket number 2020-011, cause number 475-02. In the matter of the request for agency action of, oh, I'm not repeating myself. Yes, I'm an idiot. Sorry about that. Docket number 2020-012, cause number 196-51, in the matter of notice of agency action by the Division of Oil, Gas, and Mining seeking an order, 1, forfeiting the reclamation bond provided by North Star Gas Company, Inc. of Texas for the State 2-7 gas well located in Grand County and State 36-14 gas well located in Grand County and State 36-16 gas well in Grand County. It is my understanding that the division has been unable to provide service, effectuate service of process in the time frame necessary for the board to hear this. I guess at this point, I'd like to have a report from the division on this matter.
Thank you, Vice Chair Hansen. So under the board's procedural rules, notices of agency action are required to be personally served on respondents no later than the 15th day of the month preceding the month in which the hearing is to be held. So generally, the division effectuates personal service through the use of certified mail with a return receipt requested. And under the rules of civil procedure and under the board's rules, the signed green card is sufficient to demonstrate the service was proper. The owner of North Star Gas Company of Texas is a man named Kenneth McKinney. In this case, when the division filed the notice of agency action, the division had 2 addresses on file for Mr. McKinney, and the division was unsure which address was his, so we sent the notice of agency action to both addresses. And I monitored the tracking very closely, and it became apparent that neither notice of agency action would be delivered and that a service would need to be effectuated some other way. So over the course of several days and many hours, I tracked down the last 4 known addresses for Mr. McKinney, and 3 of those were apartment complexes. And of those 3, 2 of the apartment complexes were willing to confirm that Mr. McKinney was not a resident. And the 3rd apartment complex declined to give any information on their residence. The 4th address I found was of a home that was owned by someone else. So I ran a similar trace on the owner of that home and found a phone number. And upon calling that phone number, the woman confirmed that she does own that home that she uses as a rental property, and that she was able to confirm for me that Mr. McKinney does in fact live there, and that she was even willing to give me his phone number. So as it turned out, that address was one of the 2 addresses that the division had sent the original notices of agency action to. And the phone number she gave me was actually the phone number I had on file that I had been trying to reach Mr. McKinney on numerous occasions in the preceding weeks. So it became clear that Mr. McKinney was refusing to accept service of process for the notice of agency action. So the division contracted with a process server in Houston, Texas to serve the notice of agency action on Mr. McKinney, and they were successful on their first try. And they served Mr. McKinney on June 11th, 2020. So because the rules require that service of process be made by the 15th of the month prior to the hearing, and because Mr. McKinney refused to accept service by certified mail, the division is concerned that service of process was not effectuated in time for this matter to be heard at this hearing. And we would like to prevent any possible claims from Mr. McKinney that service was improper. So the division respectfully requests that this matter be continued until the July docket so that we can be in compliance with the board's procedural rules.
Okay, thank you. So it is going to be continued. Yes, Ms. Davis.
Ms. Sousa, this is in Grand County. We've had some trouble with wells in Grand County not being connected to pipelines. Is this well connected to a pipeline that is working? Is it connected to the processor that has been down as well, or at least partially down?
I believe these wells are connected to the appropriate infrastructure. They are capable of producing. They have produced in the past, but they are currently shut in. And Mr. McKinney has refused to work with the division on either bringing them back into production or plugging and abandoning, which is why we are taking the current action to forfeit the bond and do the work ourselves.
Thank you.
Mr. Moon. Oh, I'm sorry, Mr. Moon. Mr. Borden.
Thank you. Just a quick question. Do any of these wells pose a risk of imminent contaminant release or cross connection? Any concerns like that?
So these wells, the reason that the division determined that we needed to bring this action is because these, one of these wells, oh wait, no, I'm thinking of the Patmos matter. No, none of these wells pose an immediate threat that would require we hear it today as opposed to the July docket.
Thank you.
Board members, any other questions or concerns? Seeing none, I believe we'll need to make a motion to continue this matter until the July hearing so that we're in compliance with the rules governing the board. So if someone could make a motion to continue this till
I
July.
move that we continue this matter to the next hearing.
Thank you, Mr. Church. Is there a second?
Second.
Thank you, Mr. Borden. The matter has been moved and seconded. Is there any discussion on this motion? Seeing none, Ms. Carter, could you perform a roll call vote?
Mr. Richard K. Borden, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote?
Yay.
Vice Chairman Chris Hansen, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Yay.
Mr. Vice Chairman, I have 6 affirmative votes.
Thank you, Ms. Carter. The vote was unanimous. This matter will be moved until the July hearing. Before we move on to the next docketed item, I'd like to take just a 5-minute break and come back at 10:46. If that's agreeable to all. Seeing no objection, we'll go off the record for 5 minutes. Thank you. Thank you. We're going back on the record. The next docketed item is docket number 2020013, cause number 191-08. In the matter of request for agency action of Running Foxes Petroleum Corporation, aka Running Foxes Petroleum Inc. Division, could you update us on the status of this matter, please?
Sure, this has also been assigned to a hearing examiner. In this matter, Director Baza will serve as the hearing examiner, and it is currently scheduled for July 14th at 2:00 p.m. And again, the division anticipates that the hearing examiner's proposed order will be presented to the board at the board's regularly scheduled July hearing.
Okay, thank you. We have no further action on this at this time, so we'll move on to the next item, which is docket number 2020-014, cause number E/001/0179. In the matter of the agency action, in the matter of the notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order, 1, forfeiting reclamation bond provided by Firestar LLC for the Elephant Canyon Exploration Project, and 2, authorizing the division to use the amount forfeited to reclaim the surface and subsurface of the Elephant Canyon Exploration Project. Ms. Sousa, would you like to give us an update on that as well?
Chairman Hansen, this is Gordon Rowe, and I'm actually the one handling this matter. And
I'm sorry.
The division, no, it's fine. The division filed a motion to dismiss this matter on June 22nd because the division and Firestar LLC have entered into a stipulation to settle the matter without action from the board. This motion was granted yesterday. And just to be clear for the record, this was intended to be dismissed without prejudice under the rules of civil procedure. So that's all that's, the division has to say for this matter at this point.
Thank you. I appreciate that, Mr. Rowe. That concludes the discussion on this matter. We'll move on to the next item on the agenda, which is docket number 2020-015, cause number 076-02. In the matter of the notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order, 1, forfeiting the reclamation bond provided by Patmos Energy LLC for the CBM-1 well, 2, authorizing the division to use the amount forfeited to plug and reclaim the well, and 3, authorize the division to take any additional action. Division, could you update us on the status of this matter?
Sure, and I may request Mr. Mayo to step in also if he has anything extra to add, but this matter, the operator in this matter is currently in bankruptcy in Alabama, and the trustee for that bankruptcy case has retained Mr. Mayo to represent them in trying to get this well plugged. So Mr. Mayo has filed a motion to continue, and the board granted an order continuing that, including the requirement that the trustee file the appropriate paperwork with the bankruptcy court, which I believe he has. I've seen that come through, and actually a hearing is set on that matter to grant the trustee authorization to move forward with the plugging of that. And that hearing is currently scheduled for July 14th at 8:30 a.m. Mr. Mayo, do you have anything to add?
Just thanks for the division. I know this well has been languishing for quite some time. I was retained on June 10th at about 2 o'clock in the afternoon, and was able to get a motion to continue on file shortly after 5 o'clock that day. But I have been assured by my client, the trustee, that they intend to do this. As Ms. Sosa said, they have filed this request. I believe it's an application to employ or something of that nature with the bankruptcy court, seeking to get the bankruptcy court's permission to hire this contractor to plug and abandon the well. Ms. Sosa has indicated to me that the contractor they're purporting to hire is reputable and someone the division feels comfortable with. And so a couple questions I had, I didn't see, I noticed on the agenda, it says under this matter that a motion and order will be coming if this is to be continued. Ms. Sosa represented that an order was granted, and it may have been, but I don't recall one being granted to continue this. If it has, I apologize for the confusion. The other thing is this new information that Ms. Sosa just said about the hearing date in the bankruptcy action being set for July 14th. What I would ask is given the fact that it is July 14th and will not be decided prior to the July 10th deadline to file any sort of continuance, should the bankruptcy court have concerns or not exercise its discretion to grant it at the current time, that an exception be made to allow for any filings within a day of that entry of that order if the bankruptcy court does what it does and it doesn't comport with what we anticipate it doing here.
Division, do you have something you would like to discuss or add on regarding that request?
No, that request is fine with the division. And Mitch, I just forwarded you a copy of that order so you have it for your records.
Thank you. I appreciate that.
Okay. Yes, Ms. Davis.
Just a clarification, I thought the July 14th date was a hearing examiner date. Is that correct?
No, the bankruptcy court needs to hear the trustee's motion on its application to employ. So my understanding, I'm not a bankruptcy attorney, so I don't fully understand all of these proceedings, but I believe that the trustee needs authorization from the bankruptcy court to use funds of the estate to go out and do the work. And so the hearing on whether or not the bankruptcy court will grant their application to employ Gray Rock to go out and do the work, that is the hearing that will be scheduled on July 14th.
Okay. Any other questions from board members? Seeing none, I don't believe there's a motion required, so we will hope that things go forward as planned and as expeditiously as possible. We'll move on to the next and final docketed item. This is docket number 2017-013, cause number RONG-2017-01. In the matter of informal rulemaking associated with the 2017 and 2018 legislative amendments concerning force pooling and the need to initiate rulemaking on other emerging matters, including but not limited to rulemaking on ownership designation. I believe at this point the division has a presentation they would like to make. I'm not sure who's going to be giving that, but division, please proceed.
Vice Chair Hansen, I actually have a request. Can I please take a quick break and caucus with my client, maybe for 5 or 10 minutes?
Sure, let's give you 10 minutes, and if you need more time, let us know. We'll be back when you're done.
Sounds great. Thank you so much.
We'll go off the record. Thank you. this rulemaking matter. If you would please proceed.
Thank you. Let me put this presentation up. Okay, can you all see my screen?
Yeah,
Can
I
you
see
guys
it,
see the
Haley.
presentation?
I see it.
Thank you, Gordon, for confirming. Okay, so this is just a quick update on the status of rulemaking. So on horizontals, the division sent a draft of the division's latest round of edits to the horizontal rules on May 22nd, 2020. And so far, the division hasn't received comments from UPA specific to the horizontal rulemaking, but the division is in receipt of a different letter from UPA, which was sent to the board, and I will discuss that letter on the next slide. And the division had a phone conversation following when the division sent out the rules with Tony Hunter, and he brought up a number of concerns. And I don't want to go into the concerns in detail because we aren't at a place yet where I think horizontals should be discussed in a robust manner. But I wanted to bring to attention that Tony Hunter has brought to the division several concerns. One of those is the issue of notice. Tony Hunter believes that notice should be provided to mineral owners, and that horizontal well siting affects correlative rights. So those mineral owners should also be noticed. Another concern that Mr. Hunter raised was that he believes that the distances should be uniform throughout. The division is not opposed to looking at that recommendation. We noticed that there are some different distances, and Mr. Hunter suggested that we use 660 throughout. Another issue is under the current horizontal rules, the division effectively administratively determines the pools, and Mr. Hunter believes that a pool should be determined at the board level through a board order. And the current rule implements temporary spacing in unspaced areas, and so Mr. Hunter's concerned that without some sort of temporary spacing regime, that the horizontal rules may pose some problems in unspaced areas. So I don't want to spend a whole lot of time talking about these concerns in detail, but I did want the board to be aware that there have been concerns raised by Mr. Hunter, and while we haven't received any comments from UPA, the division anticipates that UPA may have some similar or competing concerns as well. And so the division really brings this to the board's attention just to note that there is additional work that is required on the horizontal rulemaking. So as you guys received, UPA sent a letter to the board wherein it requested that the board reevaluate and prioritize its current rulemakings. And UPA pointed to several reasons why the board should consider this. Some of those reasons included challenges to the industry, such as unprecedented low oil prices, resulting in reduced production and corporate restructuring and layoffs. And UPA also pointed to some challenges that the division is facing during this time, such as budget cuts and necessary actions that the division needs to take in response to the legislative audit. And the letter requests that the primary request seems to be that the board put off horizontal rulemaking and focus on the rulemakings that are statutorily required based on the last legislative session. So the division wanted to apprise the board of all of the rulemakings that are upcoming. You can see there's quite a few. So this list includes both the oil and gas rulemakings as well as the minerals rulemakings. It's important for the board to be aware of the rulemakings on both sides so that everyone can understand the workload that is coming our way with the amount of rulemakings that we have. So the statutorily required rulemakings are those that resulted from an amendment or a new law in the last legislative session. And when those bills are passed, agencies have 180 days to implement the necessary rulemaking that comes along with the amendments. And so there are 3 rulemakings that are required by statute. Those have a November 8 deadline, and those are the oil and gas penalties, the small mines amendments, and the basalt amendments. So the oil and gas penalties affect the oil and gas program, while the small mines and the basalt affect the minerals program. There are also additional rulemakings that the division considers to be high priority or the board has ordered in the past. So the division believes that bonding is a high priority and thinks that it's incumbent upon the division to pursue changes to the bonding structure as a response to the legislative audit. In the past, the board has ordered the horizontal well rules as well as changes to the mineral suspension rules that came about the last time that those rules were considered by the board. And then additionally, there's another rule making that the division believes is necessary to undertake, and that is for seismic exploration. And
Haley, this is John. Can I jump in here for just a second?
yes, please.
Mr. Acting Chair and members of the board, I just wanted to point out on this slide as well that under the board ordered items, I think we need to recognize that when the board set these priorities, it was pre-pandemic, it was before the economic disruption that has occurred in the extractive industries. And I think that if you were to hear from either UPA or UMA today, they would probably tell you that things have changed in their business plans and processes. So even though the board prioritized this clear into last year, circumstances have changed. Under the division's high priority with bonding, I did feel like that was something that the legislative audit called us out on. And I do feel that sooner rather than later, we're going to be held accountable to address bonding, to do an adequate review of what our rule processes are. So that's why the division feels that's such a high priority. Under division recommended, that's something that has been in the works for quite a while, and it involves things involving how we permit seismic exploration, how we do reclamation on shot holes, kind of the whole process. Those rules haven't been updated for nearly 30 years and probably deserve another look in light of what's happening in that realm of exploration today. So I just wanted to add those comments. Thank you.
Thank you, Director
Thank you, Mr.
Baza. And
Baza.
that was something I meant to mention at the beginning, was that if I missed something or if John thought that there was additional information to add, that he would jump in. So thank you, Director Baza, for doing that. So the next two slides are draft timelines. So the division has been in recent contact with members of UPA and understands that there may be concern that this is an aggressive schedule. And so it's important for the board members to note that this is a draft schedule that the division is putting forward, but is doing so without the input of any stakeholders. And so prior to finalizing, it may be wise to consider the thoughts and opinions of additional stakeholders prior to implementing any sort of scheduling order where we lay out the proposed timeline in a more firm medium. So currently this is the division's proposed timeline is that, so remember these three rules we have are statutorily required to be completed no later than November 8th. So in order to break those up a little bit, we propose that on July 22nd, at the July 22nd hearing, which is the next board hearing, that we will be ready to send the small mines to formal rulemaking. Those small mines are minor modifications just to the size of mining operations for large and for small operations. Also, at the July 22nd hearing, absent comments that may require additional thought and consideration, the division hopes to be able to adopt the operatorship rules. Remember, last month we were able to send those to formal rulemaking, and that comment period wraps up soon, and we can hopefully address and adopt those at the July 22nd hearing. In order to meet the November deadline, we really need to send the oil and gas penalties bill and the basalt bill to formal rulemaking on August 26th. It's given the amount of time for public comment and the intervening timelines, it has to be done at that meeting. So the division proposes that we send the oil and gas penalties and the basalt to formal rulemaking at the August 26th hearing. At the September 23rd hearing, we would like to send bonding to formal rulemaking. We understand this is ambitious. We understand that additional stakeholders may believe this is not a reasonable timeline to get the bonding done. But this is what the division is currently proposing. Also, at the September hearing, we can adopt the small mine rules that we sent to formal rulemaking at the July hearing. And then this October 28th hearing is another absolutely must hit date. We must adopt the oil and gas penalties and the basalt rules at that hearing in order to meet the November 8th deadline. So then the division proposes that we turn our attention back to horizontals for the December 9th hearing and potentially send the horizontal siting and the mineral suspension rules to formal rulemaking at the December hearing while adopting the bonding rules at that hearing. Again, this is an aggressive timeline and this has not been vetted by stakeholders, and additional comments may be or should perhaps be considered in determining whether or not this is a reasonable timeline. But this is just what the division has put together as a proposal for this hearing. In the January 27 hearing, going into 2021, we can then adopt the horizontal rules and the mineral suspension rules. And then during Q1 of 2021, we can start looking into the seismic exploration rules, send those to formal rulemaking, and after the relevant comment period, adopt those seismic exploration rules as well. So that is the end of my presentation. Does anybody have any comments or questions that they would like for me to address?
Thank you, Ms. Sousa. I believe that Ms. Davis has a question.
Haley, what is the relationship between oil and gas penalties and bonding? I see that those are separate rules, but they seem like the same thing to me.
So they're similar, but they are slightly different. So with oil and gas penalties, what that looks like is if an operator violates some of the rules, the administrative rules. So say like they have wells shut in for an extended period of time and they don't provide the division with well integrity testing to demonstrate that it's okay for those wells to be shut in. So suppose an operator violates that. After a period of time, the division, with the penalties rule, the division can issue a monetary penalty to the operator for making that violation. Or perhaps there's a big spill that occurs and the operator fails to notify the division and fails to take action to immediately clean it up. Then in those situations, under the penalties bill, the division would have the authority to issue a penalty to that operator. And the idea of the penalties bill is that it is to hopefully help to deter violations and to help to promote this culture of compliance. The bonding is slightly different in Utah. The current bonding regime, some may argue, allows for wells to be underbonded. And when this happens, the state ultimately becomes liable. So if something happens in that well and there's not enough bonding to cover the cleanup costs if there's an environmental spill, or the plugging and abandonment costs if it's sitting out there creating a health hazard, then ultimately it falls on the division to pay for that plugging and abandonment, and ultimately the Utah taxpayers. So the changes to the bonding is really to address how we can improve our bonding system so that the state is able to reduce their liability and reduce their fiscal risks. So does it make sense how those are similar but different?
Yes, my only comment is if we don't have adequate bonds, we don't have any way to collect penalties.
Well, penalties can't be taken from bonds. So a penalty would have to be, so our bonding is only allowed to reclaim the surface and to do the plugging and abandonment work. So we wouldn't be able to forfeit a bond and then use that forfeited money to collect the penalties. The penalties would be assessed against the operator. If the operator failed to pay, then because of the new statutory construction, the board's order is effective as if it were a civil judgment. The Attorney General's office can pass that board order on to the debt collection arm of the AG's office, and they can take action towards collecting on those penalties, whether that's garnishment or tax sales or property sales, whatever they need to do to collect on that. Did that clear up the confusion?
Not totally.
Okay.
When we were talking about Patmos today, Patmos has a reclamation bond, and yet we're waiting for the bankruptcy court to allow us to use that money. I don't understand that. It seems like a bond ought to be able to be used exclusively for the right to reclaim that well.
Sure. So to be clear, the division is agreeing to work with the trustee to allow them to do the work. So in the Patmos situation, there's a bond for $120,000. The trustee believes that they can get the work done for $80,000. So if the division has to forfeit if the division forfeits the bond, then all of that 120 comes to the division, and we use whatever amount we need to use. And we have to go through state purchasing to do that, which sometimes may lead to a lengthier process or a more expensive process. So the division has agreed to allow Patmos to get authorization from the bankruptcy court so that they can save themselves the $40,000 that they think that they will be able to save if they don't forfeit the bond. So then they can do the work, they can get the whole 120 back, and their estate ends up coming out $40,000 ahead.
But to be clear, the state is protected to the tune of 120,000, and that is not part of the bankruptcy.
That is absolutely correct. Under no circumstances can that 120 go away in the bankruptcy.
Okay, good to know. Thank you.
Yes.
Ms. Souza, does that conclude your presentation?
It does.
Thank you. We appreciate this status report and this informal rulemaking process. One question before I turn it over to the rest of the board members to ask questions. When does the division feel like they will have the full input from the stakeholders, allowing the division to determine their timeline on these? This is, as you say, this is very aggressive, and it, it doesn't look like there can be too many hiccups without us going beyond the November deadline. So, again, going back to the question, when does the division feel like they'll have the input they need to finalize their timeline?
To finalize the timeline for all of the rules, or just specific to the November 8 rules?
Well, I think let's start with the November 8 rules.
Okay, so with the November 8 rules, the small mines, I believe, has already gone out for stakeholder review, and we don't expect that those will have a whole lot of comments. The changes in the legislative, in the statute were pretty simple, straightforward, and there's not a lot of wiggle room on the changes that can really be made. So I believe those have already gone out to stakeholders. On the oil and gas penalties, the division is actively working to finalize a draft that can go out to the stakeholders. I believe that the penalty schedule is nearly complete, and we're working through the specific language, which we hope to have a good, solid first draft and first discussion on next week, and hopefully have that out to stakeholders shortly thereafter. On the basalt mines amendments, I believe that those have also already gone out to stakeholders for review and comment. John, do you have anything to add?
I'm not so sure about the basalt. I think that there are some glitches in the definitions that we might have to take a harder look at, but it probably is on the same timeline to distribute as the small mining definition.
Thank you, Director Baza and Ms. Souza. I agree with you. You have some very aggressive timelines to meet the November deadline. And we all know that there's not a lot that we can anticipate in the year 2020 that could derail us. So I applaud you for setting the aggressive schedule and hope that you can complete it. Now, since this is really just an informal update, I'm not going to ask for public comment, but I would like to ask the board members if there is anything they would like to discuss on these matters. This would be the appropriate time. Mr. Borden. I believe you're on mute.
Thank you. Two questions for the division. The small mines changes, can you remind us, is that mostly related to the footprint cutoff in acres between a large and a small mine?
I can answer
That is,
yes.
go for it, John.
It was a statutory change that occurred in the last legislative session. It increases the size of the small mine limit. I think it was at 10 acres before, and it's going to 20 acres, and that is in unincorporated areas. So within developed areas, I don't think the statute changed anything, but in unincorporated areas, it basically doubled the size of a small mine.
Thank you. Second question on the bonding. Just a clarification, we are talking only about bonding for oil and gas wells for proper plugging, abandonment, and rehabilitation. This isn't going into the mining side of things, correct?
That is correct, yes.
Thank you.
Thank you, Mr. Borden. Any other members of the board have questions on this schedule or the matters presented in this summary? I see none. I guess what I'd like to do is just say to the division that to please prioritize the matters as you see fit so that they can be accomplished by the mandated legislative mandated deadline. You know best how to get this done, so we leave it up to you to make it happen. Is there any other discussion that needs to be had on this matter from anybody? Any comments? Wow. Well, I'd like to thank everybody who, I'm sorry, Mike, Mr. Brown.
I just want to say, I think the board understands why delays in the horizontal rulemaking are warranted. But I also think it's important for us to recognize, we hope that the momentum can keep moving, because I think there are, several of us that think we're beyond the phase of pilot projects and need to get horizontal rulemaking firmed up. So I'm glad to see it that it's still on the 2020 agenda. I hope it doesn't slip, but I recognize that might be the case. I just want to say that because, we worked hard to get this stuff lined up and these rules done, and I recognize that times have changed, and Director Baza's comments were very well taken, and but I think we need to continue to remember that horizontal rulemaking is a very important part of what we've been trying to get done. Thank you. I yield back, Mr. Chair.
Thank you, Mr. Brown. Very well said. I appreciate those comments. And again, thank you to the division and the operators and their attorneys who, oh, I'm sorry, not very observant. Steve, go ahead.
Yes. So just to clarify in my mind, will we be scheduled in the July hearing to adopt the operatorship rules? And if so, is there anything that needs to be done additionally today on operatorship rules?
The public comment period on the operatorship rules is still open. I'm not sure whether or not we've received any public comment. That would be a question for Natasha, but we do not need to do anything today. And if we do receive any comments during the public comment period, then the division will consider those comments, determine whether or not we need to make any changes. And then if no changes are required, then we would, at the July hearing, fill in the board on what comments were made and be able to adopt them at that time. But currently there's nothing to be done.
All right, thank you very much.
I I apologize, Mr. Church. I didn't recognize you're waving your hand. If there are any other comments, please let me know. I'll give you a few seconds. I'll keep looking at all the video feeds here to make sure I don't miss anybody else. Thank you to all who have participated today. This has been an unusual hearing, not only because we are doing this remotely, but also some of the issues were unique. We look forward to the next hearing. I think at this point, is there? Yes, I was going to entertain a motion to conclude this meeting.
So moved.
Is there a second?
Second.
Okay. We don't need a roll call vote for this, do we? No? All right. Well, all those in favor say aye.
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 And we have concluded this meeting and we're off the record. Thank you.